Students, today let us consider a problem with regard to the continuing guarantee and with regard to the contract of guarantee. As you know that the use of contract of guarantee is to enable a person to get a loan or goods on credit or an employment. That means why the guarantee could be given? Because as you know that the person who is an employer, he doesn't know the credentials of an employee. So he requests a guarantee from a certain person. So the guarantee can be given with regard to the employment. So here this can be seen under the case law of Durga Priya Chaudhary versus Durga Padarai. Here the Calcutta High Court held that guarantee for the conduct of a servant appointed to collect rents is a continuing guarantee. That means what I want to put to that, the guarantee can be given with regard to the conduct of a person who can be appointed to collect the rents on behalf of the employer. So this is the main essence of the contract of guarantee. So the use of contract of guarantee can be made either to get a loan or goods on credit or for the purpose of the employment. And as you know that there are two kinds of guarantees there. One is specific guarantee. That means a guarantee which deals with a single transaction is called a specific guarantee or simple guarantee. And the other one is a continuing guarantee. So when a guarantee extends to a series of transactions, it is called a continuing guarantee. So these are the two kinds of the guarantee. Here in the examination they will give the question with regard to the making the distinction between the specific guarantee and the continuing guarantee. So this question often will be given in the exams. This problem seems to be very simple, and we have to solve this problem with applying the provision of law with the help of the case laws, and after analyzing the problem we have to go for the conclusion. So what I want to put you that, so with regard to any problem either under the special contract, crimes, constitution, anything, we have to apply the universal accepted pattern of the problem solving, that is facts, issue, rule, analysis and conclusion. Here it may be any problem. So what we have to do, we have to simplify it. So I have simplified the above problem. Here it has been written that A guarantees payment to B of the price of 5 sacks of flour to be delivered by B to C and to be paid for in a month. B delivers 5 sacks to C. Say C pays for them. Here A stood as a guarantee for the goods supplied by B. So A stood guarantee for the payment to be made by the C. So which is for a month. So what is the agreement that? The agreement is that B has to deliver 5 sacks to the C and C has to pay for them. So here that was the transactions. But after completion of this transaction, again B delivers another consignment of force X to C. So, with regard to this transaction, C did not pay for it. So, for this transaction, whether A could be held liable. So, normally we think that the problem is very simple, and we can say that A, guarantor, he cannot be held liable for the second transaction. That means we could be able to ascertain that A could not be held liable for the transaction for which he is not a party. So that thing we can say. But we have to write in a legal way. So we have to apply the provision of law. We have to frame the issue and we have to analyze it. Then we have to give the conclusion. So here we have to make a distinction between the kinds of guarantee, whether it falls under the continuing guarantee or whether it falls under the specific guarantee. So let us go to the issue. That means, as I told you, we can frame one issue or more than one issue. So what could be the issue here? Whether A could be held liable for the latter transaction. That is the second transaction. That is B delivers force X to C after completion of the first transaction. That is the second transaction. Whether A, that is the guarantor, could be held liable for the latter transaction. That is the issue. So, which are all the rules, which are all the provision of law will be applicable here is section 129 of the Contract Act. So we have to trace our answer with regard to the continuing guarantee, and similar related case law is Kai versus Grove. So this is the facts of the case Kai versus Grove is also same as that of this problem. What we can see here, the same contents of the problem will be of the Kai versus Grove. In books we don't find the name of this case law. So that is the provision of law we have to write. So first we have simplified the facts, then we can raise the issue, then we have to write the provision of law. ಅಂದರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ, ನಾವು ಈ ಒಂದು ಸ್ಪೆಷಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ ವಿಶೇಷ ಕರಾರು ಅಧಿನಿಯಮದ ಬಗ್ಗೆ ಒಂದು ಸಮಸ್ಯೆಗಳನ್ನು ಕೊಟ್ಟಾಗ ನಾವು ಯಾವ ಒಂದು ನಿಯಮವನ್ನು ಪಾಲನೆ ಮಾಡಬೇಕು ಅಂತ ನಿಮಗೆ ಈಗಾಗಲೇ ತಿಳಿಸಿದ್ದೀನಿ. ಅದರಲ್ಲಿ ವಾಸ್ತವಾಂಶ ಬರಿಬೇಕು, ವಿವಾದಾಂಶವನ್ನು ಬರಿಬೇಕು, ನಿಯಮಗಳನ್ನು ಬರಿಬೇಕು, ವಿಶ್ಲೇಷಣೆ ಮಾಡಬೇಕು, ಮತ್ತೆ ನಮ್ಮ ನಿರ್ಧಾರವನ್ನ ತಿಳಿಸಬೇಕು. ಇದರಲ್ಲಿ ನಾವೇನ್ ಮಾಡಬೇಕು, ಇದು ಈ ಒಂದು ಸಮಸ್ಯೆ ತುಂಬಾ ಸರಳವಾದ ಸಮಸ್ಯೆ ಅಂತ ನಾವು ತಿಳ್ಕೊತೀವಿ. ಅಂದ್ರೆ ಈ ಸರಳವಾದ ಸಮಸ್ಯೆಗೆ ನಾವು ಉತ್ತರವನ್ನ ಕಾನೂನಿನ ರೀತಿಯಲ್ಲಿ ನಾವು ಬರೆಯಬೇಕಾಗುತ್ತದೆ. ಇದರಲ್ಲಿ ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ, ಎ ಅನ್ನುವ ಭದ್ರತೆಗಾರ ಸಿ ಅನ್ನುವ ವ್ಯಕ್ತಿಯ ಒಂದು ಪಾವತಿಗಾಗಿ ಅವನು ಭದ್ರತೆಯನ್ನು ಕೊಟ್ಟಿರ್ತಾನೆ. ಇದರಲ್ಲಿ ಬಿ ಅನ್ನೋವನು ಒಂದು ಸರಕುಗಳನ್ನ ಒದಗಿಸಿರುವ ವ್ಯಕ್ತಿಯನ್ನ ನೋಡ್ತೀವಿ. ಅದರಲ್ಲಿ 5 ಮೂಟೆಗಳ ಗೋಧಿ ಹಿಟ್ಟನ್ನ ಕಳಿಸ್ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ಕರಾರು ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ 1 ತಿಂಗಳ ಒಳಗಡೆ. ಅದು ಒಂದು ಟ್ರಾನ್ಸಾಕ್ಷನ್, ಒಂದು ವ್ಯವಹಾರ ಆಗಿರುತ್ತದೆ. ಮತ್ತೆ ಅದು ಆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಮುಗಿದ ನಂತರ ಮತ್ತೊಂದು ವ್ಯವಹಾರವನ್ನ ಈ ಬಿ ಮತ್ತು ಸಿ ರವರು ಮಾಡ್ಕೋತಾರೆ. ಆ ಸಮಯದಲ್ಲಿ ಸಿ ಬಿ ನೀಡಲಾದಂತಹ ಒಂದು ಸರಕುಗಳು, ಅದರಲ್ಲಿ 4 ಮೂಟೆಗಳ ನೀಡಿದಂತಹ ಒಂದು ಹಿಟ್ಟಿಗೆ ಆತ ಹಣವನ್ನ ನೀಡೋದಿಲ್ಲ. ಅಂತ ಸಮಯದಲ್ಲಿ ಏನು ವ್ಯಕ್ತಿ ಭದ್ರತೆಗಾರ ಹೊಣೆಗಾರಿಕೆಯನ್ನ ಹೊಂದಿರ್ತಾನೆಯೇ ಅನ್ನುವ ಒಂದು ವಿಷಯವನ್ನ ನಾವು ಪರಿಶೀಲನೆ ಮಾಡಬೇಕು. ಇದರಲ್ಲಿ ನಾವು ಕೊಟ್ಟಿರುವಂತಹ ಒಂದು ಒಂದು ವಾಸ್ತವಾಂಶವನ್ನು ನಾವು ಸರಳೀಕರಣವಾಗಿ ಬರಿಬೇಕು, ನಂತರ ವಿವಾದಾಂಶವನ್ನು ಬರಿಬೇಕು, ನಂತರ ನಿಯಮಗಳನ್ನು ಬರಿಬೇಕು, ಅದರಲ್ಲಿ ಅನ್ವಯವಾಗುವಂಥ ಒಂದು ಕಲಮನ್ನು ಬರಿಬೇಕು, ಮತ್ತೆ ನಮಗೆ ಗೊತ್ತಿದ್ದರೆ ಒಂದು ಪ್ರಕರಣಗಳ ಹೆಸರನ್ನು ಸಹ ಬರಿಬೇಕು. ಇಲ್ಲಿ ನಮಗೆ ಕಲಂ 129 ಅಂದ್ರೆ ಒಂದು ಕಂಟಿನ್ಯೂಯಿಂಗ್ ಗ್ಯಾರಂಟಿಯ ಒಂದು ನಿರಂತರ ಜಾಮೀನುದಾರಿಕೆಯನ್ನ ನೋಡ್ತೀವಿ. ಮತ್ತೆ ಇದರಲ್ಲಿ ಕಾಯ್ ವಿರುದ್ಧ ಗ್ರೋಸ್ ಪ್ರಕರಣವನ್ನ ನೋಡ್ತೀವಿ. ಅಂದ್ರೆ ಕಾಯ್ ವರ್ಸಸ್ ಗ್ರೋ ಪ್ರಕರಣದಲ್ಲಿ ಏನು ವಸ್ತು ವಿಷಯ ಇರುತ್ತೆ ಅದನ್ನೇ ಸಹ ನಾವು ಇಲ್ಲಿ ನೋಡ್ತೀವಿ. ಈ ಎಲ್ಲ ಅಂಶಗಳನ್ನ ನಾವು ವಿಶ್ಲೇಷಣೆಯಲ್ಲಿ ಬರಿಬೇಕು. ನಂತರ ನಾವು ನಮ್ಮ ನಿರ್ಧಾರವನ್ನ ತಿಳಿಸಬೇಕು. ಆಗ ಮಾತ್ರ ಒಂದು ಉತ್ತರ ಪೂರ್ಣವಾಗುತ್ತದೆ. ಹಿಯರ್ in our analysis section we have to deal with regard to the facts, issue and provision of law, and we have to analyze what is the concept of law. Here the issue involved here is whether A could be held liable for the latter transaction. Here, as I told you, that continuing guarantee is intended to cover a number of transactions over a period of time. So I have told you what is meant by specific guarantee and what is meant by continuing guarantee. So continuing guarantee which extends to a series of transactions, and whereas with regard to the guarantee for one specific transaction comes to an end as soon as the liability under such transaction ends. So that will be called as specific guarantee. That means a guarantee which deals with a single transaction is called a specific guarantee. So we know with regard to the kinds of guarantee, here the problem is that A guarantees payment to B of the price of 5 sacks of flour to be delivered by B to C and to be paid for in a month. Here B delivers 5 sacks to C, C pays for them. Afterwards B delivers 4 sacks to C, which C did not pay for it, and the provision of law applicable here is section 129 of the Contract Act, that is a continuing guarantee. Here we have to see with regard to the what is meant by continuing guarantee. We have seen that means continuing guarantee means a guarantee extends to a series of transactions. For example, a person has been appointed to collect the rent for a period of time, 1 year, 2 years, like that. So there are series of transactions are there, and here with regard to the present problem, there are two transactions will be there. Not true, two transactions will be there. So there we can see under first transaction there was an agreement with regard to the supply of the 5 sacks of flour to be delivered by B to C, for which A stood as a guarantee for which is going to be expired in a month. So that has to be paid for that supply of the goods within a month. So as soon as the terms of the contract finish it off, then we can say that is a specific guarantee. If it is a continuing guarantee, the transactions would have been extended. So the person A who can stood as a guarantor, who guarantees for the payment on behalf of the C for the goods which is to be supplied by B. So in the course of their transactions, so for whatever the things, whatever the aspects where the guarantor could be held liable, in order to make the guarantor the liability of the guarantor to be held liable, so there should be clear-cut agreement should be there with regard to making a guarantor liable, even though the duty of a payment which is co-extensive with a person who has to pay the amount, which could be applicable to the guarantor. But there should be a clear-cut agreement should be there. It may be with regard to the specific guarantee, or which may be with regard to the continuing guarantee. But what we have to see, we have to see the nature of transactions, nature of agreement, nature of contract of guarantee, for which a guarantor gives the guarantee. Suppose he gives the guarantee which deals with a single transactions. It can be called as a specific guarantee or simple guarantee. After the completion of the specific guarantee, the liability will be completed. So, whereas with regard to the continuing guarantee, the guarantor, he can revoke the guarantee with regard to the future transactions by giving the notice to the creditor. That has been given under section 130. So, for all these things, we have to see the nature of contract and nature of the conduct between the parties. So, in order to decide whether it is a specific guarantee or continuing guarantee, we have to see the conduct of the parties and nature of the contract between the parties. So, with regard to the instant problem, what should be our answer is that here, as this will not become a continuing guarantee, the person, the guarantor, he could not be held liable because it's not the continuing guarantee. So, A could not be held liable for the payment of C, which has to be made for the delivery of the goods supplied by B. So, this aspect we have to write, making clear-cut distinction between the specific guarantee and the continuing guarantee. So, this is with regard to the illustrations with regard to the continuing guarantee. And here we should not make a mistake with regard to the perpetual guarantee or perennial guarantee. A continuing guarantee cannot be mistaken as a perpetual guarantee or perennial guarantee. So this is with regard to the how to solve the problem with regard to the continuing guarantee. In the next class, we can see other problems concerning to the Special Contract Act.